Good afternoon. Thank you very much for joining us for the very first quarterly update for legal and compliance updates for block managers of 2022. Delighted that you're here with us today, and we've got a huge amount of content to get through. As always, we want to hear from you. Thank you so much to everyone who submitted a question in advance. And we will be asking for questions, insights, comments throughout today's webinar. You can submit those via the Q&A panel. And so onto the Q&A panel is at the top on my screen. It should be with you. Your questions will come up. We've got a wonderful question moderator on the line, my colleague Remy, who will be compiling questions into broad themes. As always, if there are questions you have about specific legal circumstances or facts, we would invite you to contact our guest today, Cassandra Zanelli, and her contact details will be available at the end of the webinar and through the follow-up mailing. As she's a practicing solicitor and able to provide advice for clients. But today we're looking more at the general impacts of what's going on the sector. As a disclaimer, and as always, today is for general information purposes only, and it should not be considered as or construed as legal advice or official guidance. That said, we will do our best to be as informative and helpful as possible. And so, Cass, for anyone who doesn't know you, would you be happy to introduce yourself?
I would indeed, thank you. And thank you very much for inviting me back for 2022 to do these sessions with you as well, much appreciated. My name is Cassandra Zanelli. I am solicitor and CEO at Property Management Legal Services.
Thank you very much. And on today's roller coaster ride, we have a huge amount to cover off. So we're starting with one of the segments that was really popular last year, which was a primer. So a high level introduction to an area of residential block management, taking people through and the intent of these webinars is to provide content and value to everybody at every stage of their career. So while some of this may be more useful to people at the start of their careers, as we go through, there will be other sections. So hopefully you find stuff useful, but we love your feedback. So we do this for you. Please provide us with feedback at the end of the webinar. Please take 30 seconds to let us know, are we covering the right stuff or the wrong stuff? Is there too much detail or not enough detail? We're here to serve you. And with that, we'd like to kick off with estate rent charges. So I guess the sort of soft, easy question to start with, Cass, is what is an estate rent charge?
If only it were an easy question. I'm a bit of a rent charge geek. And I'm noticing that there are a lot more people who are becoming interested in rent charges and estate rent charges. And managing agents and residential management companies, rent owners, may have noticed that there has been an increase and an increasing number of requests for deeds of variation for transfer deeds around estate rent charges. So I thought it was a great primer for today to kick off and to talk about variable estate rent charges and rent charges generally, so that people can understand where lenders are coming from in terms of lending requirements and why there are these increased number of requests for deeds of variation. And we're used to, in our neck of the woods, if you will, we're dealing with landlord and tenant law. And so we're used to service charges and leaseholders and landlords and managing blocks of flats. And we have 4.3 million leasehold out there. There are an estimated, and I get this figure from what I heard somebody say in conference a short while ago, that there are an estimated 2 million properties that are owned on a freehold basis, but who pay an estate rent charge. And an estate rent charge are the costs for providing services to the communal areas and the amenity land within a development. So you would have typically a development of houses owned on a freehold basis. There's some amenity land, there's some community land, there's some shared services, playgrounds, whatever it might be. And those areas, that amenity land, those services need to be provided, need to be maintained, the upkeep needs to be upkept, that's the word, in relation to those areas. And the way that that's done is by those freehold owners paying a variable estate rent charge. So there are the charges payable for the host of management functions that are provided typically by a residence management company. So it's a bit of an oversimplification, and I apologise for it being an oversimplification of this, but you have fixed rent charges that are sometimes just a matter of a few pounds that are payable. And I tend to think of those, for a way of equating them to the world that we normally live in, as being akin to the payment of a ground rent. So fixed rent charges, fixed, something similar to what we know and understand as ground rent in a leasehold context. And then you have, as I say, this other type of rent charge called a variable estate rent charge. And if you want to equate that something to our usual leasehold world, then the best way of equating that in our usual leasehold world is probably to think of it as something similar to a service charge. So a sum that's payable for services rendered. So far as fixed rent charges are concerned, under the 1977 Act, and because of that 1977 Act, no new fixed rent charges can be created. And we have a sunset clause in relation to the fixed rent charges that exist now, and those fixed rent charges will be expunged in 2037. So we've got another 15 years or so left for recovery of those fixed rent charges. But variable estate rent charges are here and here to stay. And it's that has come to people's attention, probably come to people's attention more recently, including the attention of lenders, because of the enforcement rights that a rent owner, i.e. the person who's entitled to collect payment of those rent charges, has against a rent payer, who is the person who pays the rent charges. So that's how really it's come about. And it's all rooted in Section 121 of the Law of Property Act 1925. So where we're talking about these variable estate rent charges, instead of looking at Landlord and Tenant Act or Commonhold Leasehold Reform Act, we're looking at the Rent Charges Act of 1977, which was a very good year, giving my age away there, and the Law of Property Act of 1925. And it's based on the terms of the transfer deed itself, and based on Section 121 of the Law of Property Act 1925, that a rent owner has various enforcement options open to them in the event that a rent payer doesn't pay their rent charges, whether that be the fixed rent charge or whether that be the variable estate rent charge. And those options, and we'll set them out in some detail in the ebook that follows this, but those options include an action of debt, and that's peculiar to rent charges. It's a common law remedy that's peculiar to rent charges. There is a claim for breach of covenant because of non-payment of rent. So that's the usual money claim that people would be used to. But there's also two other quirky remedies, and these are the ones that bother lenders and indeed bother those who are paying these charges. It's the statutory remedies that are available under Section 121 of the 25 Act, which include a right of entry into possession and a right to grant a lease on the charge land in trust, so a rent charge lease, and also an express right of re-entry if that's provided for in the terms of the transfer deed. And that's where lenders start to get a bit worried because of what it means when those enforcement rights are triggered or are exercisable. And as I say, Raj, we'll set out, without getting too techie about it now, we'll set out in the ebook that's sent out after this what those various statutory and contractual remedies are and why it is that lenders are getting so vexed about it. But it's because of those statutory and contractual remedies, that right of entry or re-entry and that right to enter and grant a rent charge lease, that lenders are saying, we're a little bit nervous about this. We don't want to lend against this property without a deed of variation having been entered into that either removes those enforcement rights, or in some circumstances, lenders are comfortable if those enforcement rights are tempered in some way. So maybe rather than amending or varying the terms of the transfer deed so as to remove those rights completely, that we go down a variation route whereby we temper those rights and say that we won't exercise those rights unless notice has been given to the person who's liable to pay these charges, and if they have a lender notice given to the lender as well, and perhaps give them 40 days because it's that 40-day period that's reflected in Section 121. There is, for anybody out there that's as much of a rent charge geek as I am, rent charge, there is an upper tribunal case. It's a land registration case. There are not many cases on rent charges. There is an upper tribunal one from a few years ago now. It's the Roberts case. So if anybody's bored over this weekend and wants to have a read around estate rent charges and the registration, this one deals specifically with the registration of a rent charge lease, and go and have a read of that. You will see how brutal the world is in the event of non-payment of rent charges. And that case was a fixed rent charge rather than a variable estate rent charge. But it is a brutal world in the event of non-payment, which is why we perhaps have government looking at this. Back in July 2019, they announced as part of their overall looking at stuff that's going on, the implementing reforms to the leasehold system, that they would look at giving freeholders similar rights to what leaseholders have, because leaseholders have a raft of protections, don't they, under sections 18 to 30 of the 85 Act. That's not ported into freeholders who are paying variable estate rent charges yet. So that's one of the things that government are looking at for England. Welsh Government are doing a similar thing as well. I was involved with the working group that was working with Welsh Government on that. So until such time as the English and Welsh governments look at this and look to introduce some measures and afford some protections to rent payers, then I expect that there are going to be more requests that come across people's desks. So look out for those on an ad hoc basis, and look out for them as well. We're seeing some variations done on an estate-wide basis as well.
It's interesting. And so while the workload will go up for managing agents who are facing these requests for variation, you can see why lenders would be so keen to ensure that the asset that they're securing remains as unencumbered as possible. Because I guess my synopsis there is you've got fixed rent charges which are being phased out. You've got the variable rent charges, which are the way of paying for shared services on a freehold estate. But in order for the rent charge to have teeth, there needs to be a consequence for non-payment. But the draconian nature of the rights that the chargeor has means that lenders lending the material value, the majority of the value in most cases, for the acquisition of properties across that estate feel threatened. And so variation in the absence of government action feels like a reasonable step to take.
Yeah. I mean, if you look at the Roberts case, the upper tribunal case, that confirms that your rent charge lease, for example, once the rent charge lease has been granted, it continues in existence even if the couple of £100 arrears have been paid, unless it's surrendered voluntarily. But if it's not surrendered voluntarily, it continues. It doesn't come to an end. As I say, it's a bit brutal if you don't pay your variable estate rent charges. And there aren't those kind of, with forfeiture in a leasehold context, there are all sorts of hurdles, for want of a better way of describing it, that are placed in a landlord's path before the right to forfeit becomes exercisable and the lease is forfeit. The right might have arisen, but there are things that you have to do before you can exercise them before the lease is forfeit. It's not quite like that with estate charges or with rent charges.
For those of you out there who feel that you're wasting large parts of your seat because you're sat at the edge of it because of your interest in rent charges, just a plug for Cass's Oxford Weekender, where one of the topics covered will be rent charges in more detail, and information on that will be available as part of the follow-up mail. Now,
it will be done as a breakout session at Oxford. So for those people who aren't as much of a geek as me in terms of rent charges, and I recognise that I may be in a minority with that. I don't understand it, but I may be in a minority. It's a breakout session. It's not a main session. So still come along to Oxford. Don't let that put you off.
We're starting to get questions and comments in. Thank you very much for that. So we're going to compile the comments and seek to make ask them in a general sense at the end, but just a comment that's come in. As the treasurer of an RTM company, anything that can be done to speed up the payment of estate rent charges, service charges, etc., to make it quicker and easier would be welcome. So it's
What's an RTM company doing collecting variable estate rent charges? I put that out there as a question.
And we're coming on to RTM right now, and I think this is going to be the reason why lots of people have tuned in. There is a really important case that has come out. And just as a reminder, courts don't make law, they explain the law as it has always been. And I suspect we're going to get a flurry of questions on this, Cass. But would you start possibly by giving us a background to the First Ports Property Services and Settlers case, please, and possibly maybe even looking back to Gala Unity and take us to where we are, whichever order you think is most appropriate.
Absolutely. This is, as Raj says, this is a really important case. It's the first time that an RTM case has found its way to the Supreme Court. Supreme Court doesn't deal with many cases. It's the top court in the land, and this is the first time an RTM case has found its way there. And I was lucky enough to be involved in it. I represented Armour, who intervened in this case. And it's all about the problems of dual management. And since Common Hold and Leasehold Reform Act 2002, leaseholders have been acquiring the right to manage their blocks. That's a statutory right that they have, subject to meeting the qualifying criteria, getting the paperwork right and all the processes and procedures right. They have a right to acquire the right to manage their block. And leaseholders, when they acquire the right to manage their block, get the right to perform what are called management functions. And management functions are defined under the 2002 Act. And leaseholders perform those management functions in the place of either the landlord or any other person who might exercise management rights in relation to the premises. And this case was all about what premises means, whether it's the block, whether it's the estate, and who manages the estate. Because a problem that's come up is where you have a block of flats that forms part of a wider estate. And that block might be part of a wider estate that contains other blocks of flats. So you might have an estate that consists of 10 blocks of flats, or it might be an estate with a block of flats and houses, or you might have a couple of blocks of flats and various houses, some leasehold, some freehold. There are all sorts of variations out there as to these estates that contain more than just a block of flats. Where you have that kind of scenario, so where you have a block as part of a wider estate, there's likely to be shared facilities and amenities. And those so-called estate facilities, because that's what the Supreme Court labelled them as, might be managed by either a common landlord or a third party. And the associated cost of management of the estate facilities are going to then be recovered from the lessees and the owners. The problem comes about where you have an RTM company who goes RTM for their particular block. It's what happens and what rights of management the RTM company has in relation to those estate facilities. And the estate facilities might be something simple like car parking or estate roads or a bin store. It might be on the swankier estates. It might be leisure facilities or cinemas or bowling alleys. It could be a whole host of different things that we're talking about here. Even on the simplest estates, there's probably going to be some shared estate facilities. And what Settlers Court looks at and what Supreme Court looked at is what happens and who manages those estate facilities. There have been an abundance of case law on RTM. Tune into any legal update, and as part of that legal update, no doubt there will be part of it that focuses on right to manage. I think the Upper Tribunal a few years ago called it trench warfare as to what's going on with right to manage and the whole long line of authority on it. But we have in Gala Unity, so that's a case from a couple of years ago from the Court of Appeal from a few years ago now, where you had the estate that consisted of 2 blocks of flats and 2 detached coach houses. And each of those coach houses contained a single first floor flat above parking spaces. And there was some further adjacent land, including residence parking, some footpaths, some roads, some visitor parking, grassed areas, the usual kind of stuff. In Gala, both of those blocks of flats gave separate notices claiming the right to manage, but the coach houses didn't. The RTM company said in Gala that it was entitled to manage all parts of the estate in common use, and the First Tier Tribunal, the Upper Tribunal, and the Court of Appeal agreed with Gala Unity, or agreed with the RTM company, sorry, in relation to that, and basically said that the parties should be able to get together and agree some kind of workable scheme in relation to how the estate was going to be managed. And so that introduced this prospect of what's called dual responsibility for the management of this pertinent property between the RTM company and the previous manager, so the landlord or the named manager in the lease. And that's been causing problems as to who it is that gets to manage the estate facilities and the estate services. And this came to a head in the Settlers Court case. So in Settlers Court, it's an estate called the Virginia Key Estate. And there are 10 blocks of flats on Virginia Key, 5 stories up to 11 stories, and some freehold terraced houses as well. Altogether, you have 778 residential units on the Virginia Key Estate. One of those blocks, so one of the 10 blocks, is Settlers Court. And Settlers Court has 76 flats, each let on leases, and Firstport, who are the party in the case, are named as the management company in those leases, one of the former names of Firstport. And Firstport are entitled to collect service charges in those leases and also collect freehold rent charges. Nice little segue from what we were talking about earlier, but to collect freehold rent charges from the owners of the freehold houses. And on the Virginia Key Estate, we have all sorts of estate facilities. There's a river wall, there's communal areas, there's secure parking, there's CCTV, you've got on-site concierge, you've got management facilities, you've got all sorts of stuff going on, as you might expect for that kind of estate. What happened is that Firstport, because they weren't able to reach agreement with the RTM company, continued to provide the estate services. The RTM company lessees and RTM company declined to pay contribution towards those services. So matters wound their way to the first tier tribunal, Firstport saying we have an under recovery, RTM company saying you're not entitled to recover from us. Upper tribunal say, well, we can't go behind what the Court of Appeal said in Gala Unity because the Court of Appeal binds us, and therefore they issued a leapfrog certificate to enable this to go straight to the Supreme Court. And I think that's the first time that the upper tribunals issued that kind of certificate. So to cut a very long story short, the Supreme Court said Gala Unity was wrongly decided. They say that the right to manage grants the RTM company the right to perform the relevant management functions over the premises. And that's the right to perform those functions over the premises to the exclusion of any other person, including or such as the existing manager. But, say the Supreme Court, that if you treat the right to manage as applying to the shared common facilities, that's going to cause massive problems because the RTM company doesn't have the right to collect contributions from the other residents on the estate, whether they be freeholders or whether they be lessees. The RTM company doesn't get the ability to collect contributions from other people because there's no formal legal relationship between the RTM company and everybody else on the estate. So with there being no relationship there, that there's no ability to collect those charges. And acquiring the right to manage, say the Supreme Court, doesn't give the RTM company either the right or indeed the obligation to provide those estate services. Supreme Court say that if the RTM company were right that it should provide those services, then that's just going to lead to outcomes that's absurd and unworkable. It's not going to be able to recover its costs. The RTM company is going to be insolvent very quickly. Because in this case, the RTM company would have only been able to recover 15% of the cost of the estate services, leaving an 85% shortfall. It's insurmountable insolvency issues. So on that basis, the Supreme Court say that the right to manage does not extend to the RTM company managing these shared estate facilities because those shared estate facilities do not form part of the premises over which the right to manage is exercisable. In this case, Firstport remained the sole party responsible for providing the estate services to all lessees on the estate, and therefore First Port were entitled to continue to levy charges accordingly, including charges for the estate to the lessees of the flats within Settlers Court. So it's First Port who provide those estate services, and First Port who recover the cost not only from the other residents on the estate, so the non-RTM residents, but also from the RTM lessees as well.
So that feels like a very sensible and well-reasoned decision, and I suspect led to a collective exhalation of breath across the sector as people understood that something workable was going to be there. But where does that leave people where they were previously following Gala Unity as the law was then, because the courts explained the law as that it was then, and we have now been told that the law is different and has always been different because of the Supreme Court decision? Are you seeing much across your desk in terms of people pivoting, rationalizing? I don't even know what the word is, but
worried.
Reorganizing, maybe. There's a definite reword in there, a reworking perhaps. Is this crossing your desk? Are people getting concerned about that intervening period where they were interpreting the law and applying it as per Gala Unity, but now have been told that that was an incorrect application because the law was never that?
Absolutely, because as you say, this is an interpretation of the law as it has always been. Gala Unity was wrong, it has been overturned. I've seen perhaps more activity on social media in relation to people being anxious about this than actually what's come across my desk as yet. But there are some real practical challenges that this is now going to throw up and that are going to need to be dealt with. And the court recognised that they say as their closing paragraphs that we recognise that Gala Unity has been binding authority for several years, and that there may well be many estates that are being managed under these kind of sharing agreements that have been made between RTM companies and landlords, and those agreements have been reached on the assumption that Gala Unity was right. And then the decision stops there, and they give no further guidance or assistance in the judgment as to what happens in those kind of circumstances. So it leaves that question as to what happens for those estates who have reached agreement, perhaps where the RTM company have been managing the estate facilities, but now in accordance with Settlers Court, that shouldn't have been the case. There's some other questions too. I mean, what happens with the Law Commission? What happens with the proposals that the Law Commission have put forward in relation to RTM reform? Question. Let's see what the RTM Law Commission say in relation to that. As I say, what happens with those RTM companies who have been performing these estate functions? Are managing agents now going to see an influx? And I welcome any comments that any agents who are listening to this have. Have you been seeing an influx of requests from lessees for the return of monies that have been paid to the RTM company over the last few years, where the RTM company have been performing those functions? Are we, techie lawyer point here, going to see disputes over where a block ends and where the estate starts? So what actually is now premises? Is the bin store premises, or is that part of the estate? Are we going to see an influx of tribunal cases or court cases in relation to that?
What happens, and this was raised by one of the audience, what happens if there is a multi-building estate where they all elect validly to go RTM? Can they commonly appoint?
You will still have, so on a multiple, so say you have an estate of 4 blocks of flats, each one of those 4 blocks of flats goes RTM, you will still have the landlord or the named manager, whoever it might be under the leases, managing the estate.
With no ability for them collectively to choose a different manager. Okay. Yeah. I think we'll come back to this. I'm
not sure that's attractive for landlords, I have to say, or for named managers, that they manage a piece of grass on the estate or a bin store.
No.
Watch this space on that one.
I'm sure we will come back to this as I can see the questions filling up, and would love to have them. My colleague Remy, who flashed up on screen briefly, I think possibly by clicking the wrong button, is going through the questions, compiling them, and we'll come back to it. So the next sections we rejigged because stuff has changed and keeps changing. So if we start at the very, very top, where are we on the Fire Safety Act and the Building Safety Bill? And then we'll come to what DLUC has been busy doing in a moment.
So far as Fire Safety Act is concerned, we are still waiting the risk-based guidance. So that has still yet to be published.
And the Building
Fire
Safety Bill?
Act, pausing. Building Safety Bill, that has now gone up to the House of Lords. And we had the first reading in the House of Lords on the 20th of January and the second reading on the 2nd of February. Now, although the bill wasn't amended during its second reading, if you have a look at the debate, and if you want to go online again, if you're bored over the weekend and fancy reading around this, you can go and have a look at what people were saying about this. But if you go online and have a look, the debate confirmed that there are going to be some important changes proposed at committee stage. In particular, a couple of the ones to look out for that's going to be proposed at committee stage, because committee stage is the next stage for this bill, is that government has confirmed it is going to bring forward amendments aimed at improving the position of leaseholders living in unsafe flats. It has repeated its threat to impose a legal obligation on developers and cladding manufacturers to fund remedial work unless the industry develops its own proposals and does so quick smartish. Didn't use those words, but you get the point. And while government did not explain what those amendments are going to entail, it hopes, I understand, to bring them forward before the deadline for consideration at the committee stage, and that's the 14th of Feb, so that's Monday. Happy Valentine's Day. There are several peers in the Lords that have suggested some improvements to the bill. In particular, somebody's indicated that they are going to propose widespread changes, adding 2 entirely new parts to the bill, and dealing with leaseholder protection and polluter pays principles, which there's been a lot of activity again on social media and in the press regarding polluter pays. And so there's been a suggestion or an indication that proposals are going to be made in respect of dealing with leaseholder protection and also polluter pays principles for those fire hazard remedial works. Committee stage, which is the line-by-line examination of the bill, starts on the 21st of February. So we have 14th of Feb and then 21st of Feb when committee stage starts. Again, if you are sad like me and have a look at the website, you will see that the UK Parliament website at the moment shows 57 amendment papers. So watch out for further activity on this over the next few weeks, and certainly as we get into the committee stage.
You don't have to be in the industry or even particularly interested in the industry to know that building safety is incredibly high on the things that the government is looking at. There have been a flurry of announcements. One of them has absolutely perplexed me, which is going back to the original developers and looking through SPV, so special purpose vehicle, sorry, I shouldn't use acronyms, or cutting through the corporate veil, which is one of the things that makes English and Welsh law so attractive for international trade and commerce. I'm waiting with bated breath to see actually how this will operate in practice, whether it is sort of commercial pressure applied to the house builders, or whether there will be some kind of statute or statutory instrument that peers through the corporate veil. Another
Interesting
thing,
times ahead, isn't it?
Yeah. Another
interesting
thing
for lawyers as well.
I think interesting, depending on quite how it takes, it's interesting for lawyers and society. But sort of stepping back from that philosophical question, there's also a leaseholder and resident tracking service. So what does that mean for block managers? Are you having clients ask you questions which are prompted through the release of this tool?
I'd be interested to know whether any agents that are out there are getting questions based on this. And I don't know what take up there's been. So any comments that people watching have in relation to that'd be interesting to know what's actually happening on the ground with this, because it's the new leaseholder and resident tracking service that gives residents access to online information in relation to their building status, and particularly in relation to the Building Safety Fund, so the BSF application process. And it's one of, I suppose, a number of steps that government is taking to improve transparency, so that updated information is going to be shown and published on there. I think this is the third week of every month or something along those lines, so that residents and leaseholders can track the progress of their building safety fund application. And again, government are saying that it's one of the things that they're doing to provide reassurance. So to provide reassurance to leaseholders that they're not going to be liable for the cost of the removal and replacement of dangerous cladding.
So
I'd be interested to know.
one comment has come in, which is, and thank you very much for submitting it. The person concerned is still awaiting the building codes for the buildings they manage. So maybe that is a reason why we're not hearing very much about it, because the codes are not sufficiently well distributed yet for those questions to be triggered.
Okay, because when you get, because I've looked on the website, I went on there earlier, and it is same as when you order lateral flow tests, isn't it? It's a click the green button and then you can get started.
But you require the code to get started.
Yeah.
Maybe that's something we can come back to, or if this starts to become an issue or something that people are being asked about, please let us know and we can come back to it. Or they should have them by mid-Feb. So if this ends up being something that you'd like us to discuss or look at in further detail, please let us know. If it's sort of damp squib, then we will never return to it. Next
we'll
thing,
just stick on estate rent charges.
That's both a threat and a promise. Sorry. And so on to the leasehold reform ground rent bill. Where are we up to? I know we've covered it off a couple of times, but sort of would you be happy to give a high level synopsis and where we're up to, please?
We now have the Leasehold Reform Ground Rent Act of 2022. So on the 8th of February, so 2 days ago now. Yep, we are still on the 10th of February. I'm losing track of this year. So yeah, 2 days ago on the 8th of February, the Leasehold Reform Ground Rent Bill received royal assent and became the Leasehold Reform Ground Rent Act of 2022. And when that fully comes into force, because it's not yet, but when it fully comes into force, it is going to limit the ground rent chargeable on most new long lease residential leases to one peppercorn per year. So essentially restricting ground rents to zero financial value. And it's going to prohibit the payment of administration charges in relation to peppercorn rents as well. There are special provisions that apply to shared ownership leases and leases that replace pre-commencement leases, such as voluntary lease extensions. And you have certain types of leases that are accepted from ground rent restrictions, such as business leases, community housing leases, and home finance plan leases. This is going to come into force at different stages. So watch out over the course of the next few months or so, because different things will come into force at different times. In particular, the stuff in relation to retirement homes or retirement home leases isn't going to come into force before the 1st of April of 2023. And that's because it's intended to give that retirement sector additional time to transition. By way of reminder, trading standards authorities will be able to impose financial penalties, and those are going to be financial penalties of between £500 and £30,000 for breaches. And leaseholders will be able to recover unlawfully charged ground rents through tribunals as well in England and Wales. So one to watch out for, as I say, over the course of the next few months as to when the various parts of that come into force.
Thank you. And again, just for anyone who's tuning in partway through this, there has been a flurry of activity around building safety. So we're slightly rejigging the content to hopefully make it as topical as possible. DLUC, which I believe is the accepted pronunciation of the new name for the Department of Levelling Up Homes and Communities.
Housing, yeah.
Thank you. Plans to codify residential developers' commitments to remediate buildings over 11 meters. What does that mean? Is there stuff actually behind it, or is it just another big pronouncement?
No comment in relation to that. I'll tell you what happened though instead, rather than passing comment on what on earth government are up to. You have on the 3rd of February, DLUC writing to the residential developer or property developer industry about the government's approach to agreement on building safety. The letter sets out or encloses a key features document, and that set out the government's proposed method for codifying developers' commitments. And once those commitments have been agreed, they're going to be legally binding. That letter was sent on the 3rd of February, and the deadline for submitting views in relation to that key features document was the 9th of February, so yesterday, 6 days to reply. And this reflects the government's two fundamental propositions that developers must, firstly, commit to remediating those buildings which they played a role in developing or refurbishing, and secondly, to contribute to a remediation fund for all other 11 to 18 metre buildings with defective cladding. So the key features document, go again, it's home time, it's homework, isn't it? Go and have a read of this key features document, because it defines buildings as those being over 11 metres that require remediation work, that have either been built or refurbished within the last 30 years. Alas, it doesn't tell us what remediation work means, despite the fact that it tells us what a building is. And the developer for these purposes is going to be an entity with profits or expected profits from the development of residential land in excess of 10 million per annum, or on average per annum over a specified period, or a developer that elects to join the scheme. The letter does warn, and this is perhaps what's attracted the press attention, does warn that those who fulfill the developer commitments are going to continue to enjoy, is what the wording is, continuing to enjoy the benefits of the government's services and support on financing, procurement, planning, building control, housing investment, and industry development and leadership. Whereas those who are unwilling will not. So it is a bit of a warning.
Quite a stick there. Either play by our new rules, or we will make it nigh on impossible for you to do that which you do.
Yes, yeah. It's expected that by the middle of this month, the government is going to announce and that those developers who do sign up to the agreement and those who are freeholders will not initiate forfeiture proceedings against leaseholders regarding charges or costs associated with the remediation works as well. So watch out for some further stuff coming in relation to that.
Thank you. And there's even more newish stuff. 2 weeks old, I think it is roughly. The FCA has taken up arms against insurance costs. So it's called a Dear CEO letter. What's happened there, and what does it actually mean for building managers?
Yeah, end of January, we have the Dear CEO letter sent out by the FCA, sent to insurance companies, and a Dear CEO letter sent to insurance intermediaries as well. And this is all in light of the continuing concerns raised by Parliament, consumer groups, and others about the rising cost of insurance for apartment blocks and other multi-occupancy buildings. And it's where those costs have increased significantly, and where those costs are being passed on to residential leaseholders and other affected property owners. It's an issue that we've been talking about for a while, haven't we? We've been talking about the insurance market hardening. We've been talking about the massive increase in insurance premiums that are now being paid or being sought to be recovered from leaseholders. And the FCA have now wandered into the fray in relation to this as well. And the FCA says that because of the increased costs for insurance, that it's contributing to many leaseholders and property owners facing financial difficulties. So in their letter, the FCA has set out, I suppose, various expectations, including expectations for action firms can take to help leaseholders, both individually and by identifying collective industry solutions. And they have reminded firms of their obligations under the rules, including to consider the cost borne by leaseholders when determining whether a product is fair value or not. They've outlined their plans to collect information to examine firms' approach to insurance and pricing for multi-occupancy building, and said that they will intervene further if insurers, brokers, or regulated property managers are not fulfilling their regulatory responsibilities. They've also published the Michael Gove letter, Michael Gove from Sec of State, in which he requests the FCA, in close consultation with the CMA, so Competition and Markets Authority, to shed some light on why we're having and what the underlying causes are of these year-on-year price increases for multi-occupancy residential buildings, and also to assess the causes of why there is a restriction on the coverage that's available for those buildings.
So, and I think that's the way I look at it as a novice and outsider, and I'm happy to be shouted down by the audience on this. So the year-on-year price increases are in part an effect, assuming there are no abnormal profits, and there may be some abnormal profits out there. And the reason is the risk profile has shifted for insurers. All they do is, I say all they do, one of the key things they do is price risk, and the risk profile has shifted for multi-occupied buildings, so blocks of flats, because of fire safety, the inherent costs of fire safety, but also a rising cost base where labor and materials for remediating damage have also increased. So there are inflationary pressures and a shift in risk profile. I am assuming that this sort of joins up with the DLUC announcement of polluter pays and other announcements that have come out around installation of fire alarms in place of waking watches and the like to reduce the overall risk. But from a broader economic perspective, sort of broad base inflation feeds through not just directly, but if you are paying to remediate something that happens. So I'll be interested in knowing what the response is, but speaking with clients and suppliers out there, the cost of materials has shot up, the cost of labor has shot up. And if something breaks in the building, it typically needs both people and materials.
That's an issue that I'm seeing and that clients are telling me about, just for something as simple as Section 20 works, that they would have undertaken a consultation exercise last year with the intention of carrying out the project. This year, the project is now much more than it was last year when they carried out and obtained those initial 2 or 3 quotations. They only need 2, but they might have obtained more.
The question is this transitory inflation, a sort of bounce back post lockdowns, normalization, and the inflationary rate will decrease and things kind of go back to the way they were pre-pandemic, or whether this is now becoming systemic? And I think slightly starting to tend towards the latter, but this is about building management and block management and not economics. So I'm going to move on swiftly to
the look of fear in my eyes. They're going, I'm a lawyer, I'm not an economist.
Is there now a common understanding of when lenders should or would ask for an EWS1 form? This has been prompted by questions from previous webinars where the situation has changed over the period. So where are we up to, Cass?
Oh gosh, where are we up to with EWS1? Are people still getting requests for EWS1 forms from lenders? Has it calmed down a little bit? Has it not calmed down? I haven't been spoken to about it for a little while, but that doesn't mean to say that it's not still going on. And people are speaking to me a lot more about building safety generally, rather than necessarily EWS. So what's, I suppose, if I could gauge the mood of the room with that would be helpful for me to understand where people are with EWS1. Has it calmed down? It feels to me like it might have calmed down a bit. I'm about to be shut down by everybody.
Down. I'm reading comments on the way up. I think it's calmed down. However, I'm still receiving inappropriate EWS1 requests. EWS1, no, but I don't know which of your questions that was in response to. So it could be either affirmative or negative. We're still getting requests. Generally, they don't come back a second time once told the building is too low or no cladding. I'd say it's calmed down. Lenders are still requesting. So these are mainly being dealt with by residents, agents. Interestingly, the agents are getting more confident. I'm going to say thank you very much for all commenting. It seems like a really mixed bag. Okay. And as always with a poll, you don't get people who say, oh, it's kind of the way it was before. It seems either it is exactly as bad as it was or just not bad at all. But thank you very much for that. Um, I'm going to jump forward if that's okay. So
Bernie's
we.
looks to have raised an interesting question.
Oh, hang on. I am not in the right place, but you're very welcome to ask the question and also answer it.
Bernie's raised a question about the protections that house freeholders have if they have a dispute about rent charges because they can't go to the FTT or indeed the LVT if they're in Wales to ask them to determine that dispute. Because, like I was talking about at the beginning of this, that variable estate rent charges and those who pay variable estate rent charges don't have that raft of protections that lessees have. And the tribunal is a creature of statute, so can only do what statute permits it to do, and it doesn't have the jurisdiction to determine disputes in relation to variable estate rent charges. So Bernie's question, is that likely to be a change with upcoming leasehold reform? I suspect so. I would hope so. I would hope that government will look at the raft of protections that are given to leaseholders. I know some people have various thoughts about how good those protections are, but there are protections there. But I would hope that government will look at those and see whether that same kind of level of protections could be introduced or something similar introduced so far as those who pay a variable estate rent charge is concerned. They do tend to be for lower sums of money than the service charge as well.
I fear this is a topic in and of itself, but it is something that is topical. So I'm going to raise it. And it wasn't, I think, in relation to anything we said, but with the soaring or increasing, depending on how you want to position it, costs of utilities, managing agents seem to be under pressure both to have agreed longer term contracts, but also being stuck by long-term qualifying agreements. And then also, if they were to do it, then and prices fell, they would be shot to pieces. Are you getting any questions about this, about the recoverability of utility charges? Do you have any words of insight? Definitely not advice, but insights for the audience.
Yes, I am getting questions about this, both in the context of what you were saying latterly there, Raj, about the liability to pay and reasonableness of the charges, but also in relation to the ability to lock these down into a contract for, given that the prices are soaring, and we all know that they're soaring, lock the prices as they are now into a contract for the next 2 or 3 years. That, if it's going to cost a leaseholder more than £100 per financial period, is going to be a qualifying long-term agreement and therefore caught by Section 20. You're not going to be able to consult because you have, as I understand it, a window of 24 hours sometimes to agree to this contract for the next 2 or 3 years. So consultation is off the table. It's then a case of applying for dispensation from consultation. I don't know that the tribunal will give you the quick dispensation that you would need. Certainly, tribunal can deal with applications for dispensation from consultation on an emergency basis. Whether it's quick enough to catch that contract or not is perhaps another matter. I suspect that lots of people will be responding with their thoughts in relation to that. But of course, dispensation from consultation can be obtained either before the contract is entered into or the works are undertaken, and also obtained after the event as well. So it's either before or afterwards. So retrospective.
Recognizing that consumers always want a good deal and don't want to have the wool pulled over their eyes, it's quite hard for managing agents, because if you were to lock in, prices fall, you look a fool. If you don't lock in and prices rise, you look a fool. And managing agents, I don't think, can reasonably be expected to know what the future price of utilities is going to be.
I don't know if agents are using utility brokers to assist.
And there are specialists out there for the block management sector.
Yeah.
Armour
members, I don't know if anybody online is an Armour member, but Armour members have the ability of Armour Energy, that it's called. But certainly that's open to Armour members, that bulk buying power.
I'm asking a question just because I wasn't aware, and I'd love to hear your thoughts. Following Michael Gove's statement in January, all media and professional commentary on his statement states that it relates to buildings between 11 meters and 18.5 meters, not 18 meters. Were they all wrong? Do you have any insight on that? Maybe we can come back on it.
That's my homework.
Okay.
That's passing it back to me instead of me handing it out.
A comment on insurance. We've seen two large insurance increases, 6k to 50, 6k per annum to 52k per annum, and 21k to 50k. One of these had a period of 26 days not insured because underwriters were not willing to provide cover. We ended up with joint underwriters insuring the business to share the risk. Yeah. That is terrifying.
It is.
But
and
also,
there are buildings out there without insurance. That's equally terrifying.
Hopefully, as the cladding and fire issues de-risk, the materiality to insurers will also, the sort of risk reward profile will shift for insurers. One of, I guess, my worries is the sort of Dear CEO's letter is akin to, could you please cap your prices or reduce your prices? And my fear is that we see an outflux of insurers from the sector, and that I don't think leads to a vibrant market or a great place for our clients or their clients' clients. So
no, there needs to be a competitive market out there.
Some very specific questions were asked around the Settlers case, and I'd say for those, could you please contact Cass directly? It sounds like in some cases you might want specific advice on the specific facts of what you are dealing with. And the clarification on the comments about estate rent charges and the RTM at the outset is probably good just to tie that up. The RTM company manages an estate with a mixture of freehold and leasehold properties. Freeholders pay into the general purpose fund that maintains the common parts. So just a clarification there from whoever it was on the line. And with that, there were a very large number of specific questions. Hopefully you have found this useful. Please take 20 seconds, 30 seconds if you'd like to write a lengthier comment to let us know how we're doing. Is the primer useful? If not, why not? If so, which topics would be useful to you? What would you like us to focus in on the next quarterly update? We do a case update. Hopefully Settlers was the right one to choose given the impact across the sector. Please steer us. We do this to help you. And as a reminder, you can keep up to date with all of the webinars and other guides through all good social media channels. You're going to receive a follow-up email with further information, ebooks. Please, again, provide us with feedback. And please also, if you haven't looked, Cass, are there still tickets available for the Oxford Weekender?
There are 7 weeks tomorrow. We are taking over St Hugh's College, Oxford. We are there from Friday until Sunday, staying over in student accommodation on the Friday night and Saturday night. And trust me, the student accommodation these days is far better than it was back in the 90s, back in my day. It's en suite, double beds. It's amazing. So we all get together at St Hugh's. We stay at St Hugh's. We dine at St Hugh's in their fantastic dining room. It's all very Harry Potter-esque. And over the course of the weekend, you get to hear from the industry's greatest leading speakers presenting 40-odd different sessions that are taking place. Raj will be there as well. He's kindly agreed to moderate one of our breakout rooms. So we have a bunch of keynotes and panel sessions and breakout sessions. It's a fantastic weekend.
And better quality food than pot noodles, I hope.
Absolutely. Was that your student days?
That was. Thank you all so much for joining us today. Please take, really grateful if you could take 20 to 30 seconds just to provide us with feedback as we start to flesh out what we're doing. Thank you all so much for attending. And Cass, thank you very much too. Great to speak with you and thank you for preparing. Have a wonderful rest of the day, everybody.
You're very welcome, and hopefully see you in Oxford.
Thank you.